At 6:47 this morning, federal marshals entered Mar-a-Lago carrying a 127-page document. On page 73 of that document is a single line, just 7 words, that explains why this is not an ordinary legal dispute. Before I tell you what those 7 words are, you need to understand something about presidential asset forfeiture that almost no one is talking about. Subscribe right now and turn on notifications. What I'm about to explain isn't on cable news because it requires reading 127 pages of legal filings that most outlets won't touch. You're here because you want real analysis. Here's what matters. The issue is not that $540 million was seized. Everyone knows the marshals arrived. Everyone has seen the footage. What people are missing is how they legally justified it. And that legal pathway changes everything about presidential power going forward. Federal prosecutors did not only argue that Trump committed a crime. They argued something far more consequential. Something that shifts this from a documents dispute into what legal scholars are calling one of the most dangerous precedents in modern American history, not for Trump, but for the office itself. Those 7 words on page 73 are why Trump's lawyers went completely quiet for 11 hours yesterday. No statements, no emergency filings, no posts from the legal team. 11 hours of total silence from attorneys who are usually very vocal. That silence says a lot. Stay with me, because what I'm about to walk you through is not speculation, not theory. It is written in federal court filings right now. And once you see it, you can't unsee it. Let me show you how federal asset forfeiture actually works. This is where most coverage gets it wrong. People think prosecutors had to prove Trump guilty of a crime they didn't. Under 18 U.S. Code Section 981, prosecutors only had to show that the money itself is connected to criminal activity. That is a completely different legal standard with very different consequences. Civil asset forfeiture does not require a criminal conviction. It does not require proof beyond a reasonable doubt. It requires what's called a preponderance of the evidence, meaning just over 50% likelihood. Think about what that means. Prosecutors do not need to convince a jury that Trump committed espionage. They only need to convince a judge that it is more likely than not that specific assets came from unlawful conduct. This is the route prosecutors use when they cannot, or do not need to, secure a criminal conviction, but they can trace the money. And money can't invoke the Fifth Amendment. Money can't refuse to answer questions. Money just sits in accounts and storage facilities, waiting to be tracked, which brings us to the 3 things prosecutors had to show the federal magistrate judge before he signed the seizure warrants. First, tracing. Prosecutors had to trace $540 million from specific alleged conduct to specific assets. Not vague claims, but exact dollar amounts moving through named accounts on precise dates. This is why the Deutsche Bank records matter so much. Trump's personal banker at Deutsche Bank was Rosemary Vrablic. She resigned in December 2020 under circumstances the bank has never fully explained. What we know from court filings is that prosecutors subpoenaed every wire transfer she handled for Trump between 2017 and 2023. Every single one. What they uncovered was a network of shell companies moving money in patterns that financial crime specialists describe as sophisticated laundering. Funds would leave one Trump-controlled entity, pass through a Cayman Islands corporation that exists only on paper, then reappear as purchases of artwork, rare books, or wine collections. The path was intentionally complex, but prosecutors had documentation. Bank records showing Trump Entity A wiring funds to a Cayman entity, then invoices showing that same Cayman entity buying a Picasso days later. Second, nexus. This is the legal term for a substantial connection between the alleged offense and the property. It's not enough to show that Trump has money. Prosecutors had to show that classified material was used to secure foreign investments that generated the profits used to buy the assets. This is where the timeline becomes critical. Saudi Arabia's Public Investment Fund made major investments connected to Trump-related ventures in 2023. The same year, prosecutors allege classified intelligence assessments were provided to foreign investors in exchange for favorable investment terms. I'm quoting directly from the filing. The defendant provided classified intelligence assessments to foreign investors in exchange for favorable investment terms, resulting in capital inflows exceeding $2 billion between March and November 2023. Major asset purchases begin in April 2023, 1 month after the alleged exchange. That is nexus. That is the direct connection the law requires. Third, risk of dissipation. Not flight risk for Trump personally, but risk that the assets themselves would be moved beyond reach. This is why the seizure happened at dawn with dozens of marshals, instead of a routine court order asking that assets be preserved. Prosecutors presented evidence that $340 million had been moved through 17 shell entities in just 6 months. When that much money is moving that fast through that many structures, prosecutors argue the owner is preparing to conceal it from the courts. Judges do not authorize armed seizures casually. When a judge sees evidence that assets may disappear, the law allows immediate action to preserve them. That is exactly what happened here. The judge saw the transfer patterns, concluded the assets were at risk, and signed the warrants. If you're following how extraordinary this legal mechanism is, hit that like button, because what comes next makes it even more significant. The question is not only whether prosecutors proved those 3 elements. The real question is what specific offense they traced the money to. And that's where page 73 comes in. Here are the 7 words. Page 73, line 14. Intelligence product exchanged for financial consideration, March 2023. Read that carefully. Not mishandled, not improperly stored, not accidentally retained, exchanged. That single word changes the entire case. Mishandling classified documents is an Espionage Act violation with a maximum penalty of 10 years per count. But exchanging intelligence for payment is not mishandling. It is commerce in classified information. And that triggers an entirely different statute. 18 U.S. Code, Section 794, delivering defense information to aid a foreign government. When classified intelligence is exchanged for money, you are no longer in document retention territory. You are in espionage for profit territory. And the penalty for that is life imprisonment, or in extreme cases, capital punishment. For context, consider past cases. Aldrich Ames, a CIA officer who sold intelligence to Russia for $4.6 million, received life without parole. Robert Hansen, an FBI agent who sold secrets for about $1.4 million, also received life without parole. Both involved exchanging intelligence for financial benefit. Now prosecutors are alleging that Trump engaged in the same category of conduct, though not necessarily the same structure, and on a far larger financial scale. According to the seizure documents, $540 million in assets are traced to intelligence exchanges. That is not comparable to Ames or Hansen. It is vastly larger. And this is where the evidence trail becomes especially damaging. Look at what else appears on the 127-page seizure list. A rare book collection valued at $23 million, purchased in April 2023, 1 month after the alleged exchange. A Picasso acquired for $47 million through a shell company in May 2023. A wine collection worth $8 million cataloged in June 2023. Every major purchase traces back to 2023, the same year prosecutors allege the exchange occurred. This is not coincidence. It is documented in bank records, purchase contracts, and corporate filings attached to the forfeiture motion. This is not rumor or theory. This is what federal prosecutors presented to a judge under oath. And that judge found it credible enough to authorize the largest asset seizure involving a political figure in U.S. history. Now let's address the counter-arguments, because Trump's legal team is likely to raise 3 main points in emergency appeals, and you should understand why 2 fail quickly and why the third, while serious, does not change the immediate outcome. First, the Presidential Records Act. The claim will be that presidential records belong to the president and could be taken after leaving office. Even if that were true under civil law, which multiple courts have already rejected, it would not matter for forfeiture. Civil ownership does not protect property bought with criminal proceeds. If someone commits fraud and buys a house, the government can seize the house even though the deed is in their name. Same principle applies here. Second, political motivation. The argument will be that this is a partisan action by the current Justice Department, but the magistrate judge who signed the warrants, Bruce Reinhardt, was appointed during the Trump administration and previously represented Trump associates in private practice. According to court staff, he spent over 3 hours reviewing the evidence package. Magistrate judges usually review warrant applications in minutes, not hours. When a judge already under public scrutiny takes that long, it suggests the evidence required careful consideration and met the legal threshold. Third, precedent. This does raise serious concerns. No former president has ever had personal assets of this magnitude seized by federal marshals. Nixon was pardoned before modern forfeiture statutes applied. Clinton's finances were investigated, but never seized. So yes, this is unprecedented. But precedent, by definition, must start somewhere. The real question is whether the evidence justifies it. The judge clearly believed it did. Now here is what almost no mainstream outlet is discussing, and it may matter more than any courtroom ruling. What happens to U.S. intelligence relationships when allies believe a former president may have traded classified assessments for financial benefit? Intelligence sharing with allies operates on trust built over decades. Right now, Allied services are reportedly conducting internal reviews of intelligence shared during that period, asking whether any of it could have been compromised. Even uncertainty can damage cooperation. Court filings reference investments from Middle Eastern sovereign wealth funds in exchange for access to classified assessments about regional security threats. If that allegation is proven, it would mean American intelligence was used to shift regional power balances for personal financial gain. That is not just a domestic legal issue. That is a geopolitical one. Now let's talk about what happens to the seized assets. They are currently in federal custody. Art is in climate-controlled storage. Books are cataloged as evidence. Wine is in secured facilities. Trump cannot sell, transfer, or access any of it. Within 30 to 90 days, there will be a civil forfeiture hearing. This is separate from any criminal trial. Trump's lawyers can contest the seizure and argue the assets were not derived from unlawful activity. But again, the standard is preponderance of the evidence, not proof beyond reasonable doubt. If the judge orders forfeiture, the assets will be sold at public auction. The proceeds go into the federal forfeiture fund and are distributed to victim compensation programs and law enforcement agencies. This is how it works in all major forfeiture cases. Emergency appeals will be filed, likely going to the 11th Circuit and possibly the Supreme Court. But forfeiture appeals are harder to win than criminal appeals because of the lower evidentiary standard. Politically, notice what is not happening. There is no unified, aggressive defense from party leadership. Statements express concern about precedent, but stop short of declaring the seizures illegal. No state officials are intervening. The language is careful, and that caution speaks volumes. Here is what this ultimately comes down to. This is not about $540 million. It is about whether a president can monetize national security secrets and shield the profits. If this forfeiture stands, it establishes that presidents face real financial accountability for classified violations. If it fails, it suggests financial immunity, even when prosecutors can trace proceeds. We are watching the boundaries of presidential accountability being tested in real time, and the final answers may not come until appeals are finished years from now. One final question remains. If the alleged exchange happened in March 2023, why wait until now to seize the assets? Possible reasons. Prosecutors were building a complete financial map, waiting for cooperating witnesses, or there may be multiple exchanges, and March is simply the one they can already prove. The $540 million may not represent the full scope. It may only be what can be seized today. Emergency filings could arrive at any moment. Additional charges may follow. And when appellate courts rule, what they decide will shape how presidential power and accountability are defined for decades.